Everyone, I'm Dr. Kalpana. In this lecture, we will try to understand competition law in India. It is a comprehensive overview, and this presentation offers a detailed examination of competition law in India, and we will explore its evolution, key concepts, practical applications, and join us to deepen your understanding for vital legal field. Now, first thing is, what is the need for competition? How and why it is required? First of all, we require the goods and services due to free competition and fair competition. It enables lowering of the prices. Competition drives down the cost for consumers. This makes essential goods and services more affordable for majority of the population. Better quality because of competitiveness in the market, firms, factories, industries, firms innovate to offer superior products, and this pressure improves overall market quality. Third is innovation. Competition fosters continuous improvement. It pushes companies to develop new and better solutions. Effective, efficient allocation. Resources are directed to productive usage. This optimizes the economy's overall output. Therefore, competition is vital, important, and significant for a healthy economy, promoting fair markets, consumer welfare. It prevents exploitation and encourages innovation. Now look at the history of competition law in India, which begins in 1969 with an enactment, the monopolistic restrictive trade practices. That is the first legislation in Indian history which outlines a little about competition law, curbed monopolies and economic concentration, and enforced by MRTP Commission lacked modern tools for market abuse. So it was dropped down in 2002, and it was replaced by Competition Act 2002. Introduced modern concepts, established Competition Commission of India, and India's competition law has evolved significantly from curbing monopolies to fostering market competition. The legal framework has adapted to liberalized economy. Now, looking at the comparison between MRTP Act versus Competition Act, objective. The focus was to prevent concentration of economic power here, promote and sustain market competition. So it is a modern approach with Competition Act. Enforcement body, MRTP Commission here, Competition Commission of India is there due to Competition Act is envisages. Concept of dominance, monopolistic restrictive trade practices, abuse of dominant position, mergers and acquisitions. There was no regulation with MRTP Act when it comes to mergers and acquisitions are concerned. Covered under combinations, penalties largely were advisory in nature. Under Competition Act, binding orders with heavy financial penalties. So the shift from MRTP Act to Competition Act marked a paradigm change. It moved from restrictive focus to more proactive behavior-based regulatory approach aligning with global standards. Now coming to the key definitions here. A definition, any arrangement or understanding between parties. It can be formal, informal, written, or oral. That is the definition of agreement. Market impact agreements are relevant if they affect market. This includes direct, indirect influence. Types includes formal contracts, oral arrangements, and even tacit understanding among entities. Section 2B and 3 of Competition Act define agreement broadly. This includes even informal or unwritten arrangements that impact market as seen in the Hyundai Motor case. There are some key definitions of cartel. What is cartel? That is an important term in Competition Act. Association of producers or sellers who are the stakeholders of markets to limit or control production, distribution, price. Cartels are per se prohibited under this act. Impact harmful to competition and consumers. A cartel is a group that conspires to restrict competition. The cement cartel case exemplifies severe penalties for price fixing, such as agreements are explicitly illegal. Anti-competitive agreements, Section 3, agreements that significantly harm competition in India are prohibited under Section 3. Horizontal agreements between competitors, price fixing, output restriction, market allocation, bid rigging. Vertical agreement across supply chain, tie in exclusive deals, resale price maintenance. Section 3 of the Act addresses agreements that distort competition. This includes horizontal agreements among competitors and vertical agreements along with supply chain like producer, manufacturer, distributor, dealer, and retailer. That is vertical agreement, which is dealing with the hierarchy from top to the bottom. That is called vertical. Whereas the similar kind of businessmen who are competitor, like all distributors or producers or dealers or retailers. So landmark cases highlight the serious implications of such practices. Horizontal versus vertical agreements. So between competitors at same market level, for example, if they agree on price fixing, output restriction, market allocation, bid rigging, these are per se illegal under Section 3 of Competition Act 2002. Vertical agreements between entities at different levels of the supply chain, tie-in arrangements, exclusive supply, resale price maintenance, refusal to deal, evaluated under rule of reason. So horizontal agreements like price fixing between rivals are deemed inherently illegal. Vertical agreements such as exclusive distribution are assessed based on their actual anti-competitive effects. Abuse of dominant position. So definition is strength to operate independently, affect competitors, consumers, unfair conditions imposing discriminatory prices or conditions, limiting production, restricting goods or technical development, denial of access, preventing entry to the market, using power in one market to another. So Section 4 addresses the abuse of dominant position. This involves imposing unfair conditions, limiting production, or denying market access. So Google LLC case exemplifies the severe penalties for such abuse. Combinations, mergers, and acquisitions. Mergers, amalgamations, acquisitions, meeting asset turnover threshold. Regulatory scrutiny subject to review by Competition Commission of India. Competition Commission of India conditions. CCI can allow mergers with conditions as in Sun Pharma Ranbaxy case. Prohibition if like to have an appreciable adverse effect on competition. Section 5 and 6 regulate combinations. Combinations, mergers, they prohibit if they significantly harm competition. CCI can impose conditions to mitigate adverse effects, ensuring fair market dynamics. Now, to conclude this lecture, the changing landscape of competition, Competition Act 2002 reflects India's transition from controlled economy to liberalized market by targeting collusive behavior, abuse of market power, harmful mergers. It empowers both consumers and fair businesses. The aim is not to punish big businesses, but to prevent unfair dominance. There is a revision a table which I have prepared for you. So topic, key concept, leading case, agreement, section 2B, section 3. The case is Hyundai Motor case, cartel, explanation to section 3, subclause 3, cement cartel case, horizontal agreement, section 3, subclause 3, FICCI multiplex case, vertical agreement, section 3, subclause 4, Snapdeal versus CAF, abuse of dominance, section 4, Google Android case, combination, section 5 and 6, and Pharma Rand Bexy case. With this, I would end here.